I think I'm just going to have to potentially permanently just put this hat on my head, staple it, somehow permanently just keep it on here. But yes, in the middle of NASCAR's State of the Union, or State of the Sport address, State of the Union, wrong thing. The announcement was made, or the judge made their decision about the preliminary injunction for 2311 in Front Row. Now, there's a lot of legal speak in here. I don't speak legal speak, but someone a while ago summed this up nicely. Basically, this was the decision to determine if 2311 in Front Row get to race with charters next year, or if they don't get to race with charters next year. So let's go way back to like September when teams were given the decision. They said, NASCAR allegedly said, you have till midnight tonight to sign the charter agreement. And this was at like 6 p.m. of that day. Well, all but two of the teams signed that charter agreement. 2311 Racing, co-owned by Michael Jordan and Denny Hamlin, they did not sign. And then Front Row Motorsports, owned by Bob Jenkins, also did not sign. Both those teams have 2 charters apiece. Front Row has already confirmed that they're going to open a third charter. It is expected, not confirmed, but expected that 2311 will have a third charter. Now, of course, Stewart-Haas Racing is where those charters are expected to come from, but once again, it has not been 100% confirmed. And why is this important? Why is this so important that Front Row has 2, 2311 has 2, they might expand to 3 apiece? Well, it's important because the reason that these 2 teams did not sign the charter agreement, the new one for 2025 and beyond, is because they did not think the terms of the deal were fair. They did not think it was negotiated fairly. So what did they do next? They filed a lawsuit, an antitrust lawsuit against NASCAR, which is now ongoing. And one of the first steps in this lawsuit was a preliminary injunction, basically to get the teams that are suing NASCAR charters. Now, these charters, they guarantee you a spot in the field each and every week. For, if you have 3 charters, you have 3 teams in the field every single week, regardless of how poorly you qualify. It also guarantees you more money. I'm trying to think of other things on top of the money and the guaranteed spot in the field. I can't off the top of my head. But those are the 2 big ones. Because you look at the Daytona 500, there are 40 spots available. There are 36 charters, so 36 locked-in spots. But then there are 4 open spots, and usually we show up with about 42, 43 cars, so 2 to 3 guys miss it every single year, and it comes down to qualifying in the duels. So, and that's also the highest paying race of the year, by the way. So to miss that race would be a big financial hit, on top of already being an open team and getting less money than you would as a chartered team. So this is a really big deal for 2311 in Front Row to get their charters, or to keep their charters for 2025 as this ongoing lawsuit happens. As I said, the judge made their decision today. At this time, plaintiffs have not met their burden as required for a preliminary injunction. Should circumstances change, plaintiffs may file a renewed motion for preliminary injunction. Therefore, the court denies plaintiffs' motion without prejudice. However, the court intends to assign this case to the fast track as defined in this court's standing orders. The court directs defendants to file an answer by the already established responsive pleading deadline of December 2nd, 2024, even if it is accompanied by a motion to dismiss. The court also directs the parties to conduct the initial attorney's conference as soon as possible after the responsive pleading is filed, and to file the Rule 26F report no later than December 16th, 2024, so that a case management order can promptly issue. Later on it says, here, although plaintiffs have alleged that they will face a risk of irreparable harm, they have not sufficiently alleged present, immediate, urgent, irreparable harm, but rather only speculative possible harm. That is, although plaintiffs allege they are on the brink of irreparable harm, the 2025 racing season is months away. The stock cars remain in the garage. So yes, there's a lot to process there. There's a lot of big words. There's a lot of legal speak in there, which once again I don't do. But basically, I guess Jeffrey Kessler, the attorney for 2311 in Front Row, made the argument that there was going to be a lot of harm to the teams, that there was going to be present, immediate, urgent, irreparable harm to the teams if they did not have the charters in 2025. And I guess NASCAR argued the other way, and then this is what they decided. So I don't know. Maybe I'm underselling that. Maybe I'm simplifying that too much. I'm probably missing something here, but this is a big deal. Obviously, 2311 in Front Row, they can appeal it if they get another chance at another preliminary injunction. They can go hard at it again. I don't know if it'll get overturned, but it's a really big deal that these two teams could potentially be racing. We always knew this was a potential the instant the lawsuit was filed because they were not on that charter agreement. But it's a really big deal for a number of reasons, including the potential defending champion could be out of a ride, theoretically. 2311, I can't remember if it was Denny or Jordan or Kessler or Curtis Polk, whoever it was. Someone at 2311 said, if it's an open car next year, theoretically, Tyler Reddick's out of contract. He can leave, and also the sponsors could leave. Now, that's only a potential. That does not mean they will leave, but it means there's the potential. It's in the contract somewhere for both Tyler Reddick and I guess that would be Monster Energy. Obviously, I don't think Air Jordan. I would assume that's safe. But Monster Energy, Money Lion, McDonald's, whoever it may be, they could potentially pull out of their contract and say, hey, we're not going to sponsor you. You're an open car. We're not guaranteed a slot every week, so it's not quite worth the investment maybe. Or maybe they think that there's going to be performance fall off from the lack of money coming in. So that's a really big deal in itself. Now, even if they race as open cars, I don't think Tyler Reddick would leave. I don't think the sponsors would leave. Now, maybe a sponsor was looking to get out and this is their way out, but I don't see Tyler Reddick leaving. He left RCR on very, at the time, poor terms. RCR was not happy with how he left. And I think Reddick, he saw the vision at 2311. They've had a really successful year this year. I don't really see why he would leave next year. So I don't think that'll go through. But there are a lot of repercussions of what could happen if 2311 and Front Row don't have their charters. As I said, money, not making races, the potential for sponsors leaving, the potential for drivers leaving if it's in their contract. So, and then the next question would be, if they don't have their charters, if they're not granted the charters, what happens to the Stewart-Haas Racing charters that they have supposedly bought for their teams to open a third team for both sides? Do they vanish? Does NASCAR hold them now? Do they sell it to someone else? How does that work? I mean, there's a lot of questions here that need to be answered, but we still got a championship to decide this year. We got to get to 2025, like the calendar 2025, and then we still got a month and 3/4, really, until we get to the Daytona 500. So there's a lot to figure out still. But this is a big decision. As of today, 2311 and Front Row Motorsports only have charters for 2 more days. That's it. So 2311, Tyler Reddick fight for a championship this weekend at Phoenix Race. I wish it was Homestead Miami Speedway. But yeah, we'll do our championship preview later this afternoon. I was supposed to be filming it now, but then this came up. And then tonight we got the Truck Series Championship, so that should be fun. Hopefully I explained this decent enough. If I didn't, my bad. Legal stuff is not my expertise.